Righty.
All right, now we're going to go into a discussion
Yes.
with the lawyers
Yes.
about what they think about each of these jurors and their concerns about whether they would want them on this jury or not want them on this jury. And then we're going to have the members of the jury tell us what their thoughts are regarding the questions that were asked to them. Um, First of all, I wanted to say that I thought the lawyers did a great job, because what you're trying to do in the jury selection process is to get people talking, because it's we all have experiences that we've had. We all have biases that affect how we would sit in a certain case. People hear the term bias and they think it's all negative. No, we in the law deal with biases all the time. So we're trying to find out if this case is the kind of case that would be best type of case for us to have you sit on. For instance, if you were in a car accident last week and you are in jury selection on a car wreck case this week, I don't care what happened in the car wreck, you're probably not going to be somebody I want on that jury this week.
Right. Yeah.
So the fact that you're not good for this particular case on this particular day is an issue that these lawyers have to flesh out.
Okay.
And that's why they ask you these types of questions, because for their client it's very important that they have, an even playing field. And everybody thinks, oh, I'm not going to be, biased against one side or the other, but your past experiences really do sometimes affect what you do.
Yeah.
And so that's why these lawyers have the opportunity to talk to you. So at this time, let's have a dialogue with Ms. Moncrieffe and Mr. Dunlop about their concerns about whether to put these people on the jury. Let me also say that in jury selection, we don't pick jurors. It's not, I'm going to take Ms. Walker and I'm going to take Mr. Morgan. It's not that. We deselect. So you actually have strikes, and you have a certain number of people you can strike. And if you just don't like anybody, then you're going to have a problem, because you only have a certain number of people you can strike, and the rest of those people are going to get back on the jury. Yes.
So I want everybody to really understand, because you made a great point with the strikes. So basically, everybody who comes in for the voir dire, they're a juror until they're stricken.
That's correct. You're going to be on the jury unless and until someone is able to remove you from that. And there are two ways they can do that. You can be removed for cause, which means there's something that you said in your answering the questions that is such that there's not really a way the judge can have you sit on this case.
Okay.
So that's a strike for cause.
Okay.
And then there are preemptory challenges, which means that the lawyers don't have to tell us the reason. They have a certain number of those challenges and strikes that they can use. So let's have a discussion between Ms. Moncrieffe and Mr. Dunlap about how they would go about determining their strikes based on the very limited information you all gave today.
Very limited information.
Yes, it really is very limited. Maybe you all can talk about that too.
Sure. All righty. So, Sandre?
Okay, so I'm going to use one of my strikes for Mr. Morgan. Just one of my strikes for cause. Huh?
Why is that?
So I'm concerned that Mr. Morgan got a little confused, was already getting a little confused about the terms of art that we use. And some of that was probably your fault. Like when I say words like imminent danger, and when I say, I think it was something that Stacy said, and then in the trying to apportion a percentage to
Yeah.
to the standard, because that I could see him back in a jury room, and we're just talking frankly. I could see him back in a jury room winding up with my entire jury confused.
Well, but the question was, you did not clearly lay out what these things meant.
Mm-hmm.
So therefore,
Well,
wait, no, let me finish speaking here. But you did not lay out clearly what these terms meant. So therefore, the confusion was that we would have this wide spectrum. And I think that, but the same way that you're asking us different, questions for voir dire, I should be able to say, what exactly do you mean here? I don't know exactly. If you use a term I don't know, it's not improper for me to ask a definition. And I also think, too, from my perspective, first off, I knew you were going to strike me because of the question that I asked. But because, and my bias is this, because you want to make your case and you don't want to have somebody in there who might say, wait a minute, this is a thinking person. I want to get these people to hear my narrative versus somebody who might look at things very objectively. So I was expecting to be stricken by you.
So, and I will also say, we only had an hour for this. So technically, Sandre probably, and Stacy probably, and you guys can correct me if I'm wrong here, when y'all are actually doing this proceeding, you all are talking to the potential jurors for a very considerable amount of time, not 10 minutes at a time. Y'all are doing this, and I would assume that during your presentation, before you get into the questions, you're spelling out those definitions and going through that even more. So time constraint kind of limited us here with getting to that depth of information.
That's absolutely true. I like to give the lawyers as much time as they want in a voir dire examination, because it is very difficult to kind of flesh out those things and to have the jury understand it. But Mr. Morgan, you are not the only person that would walk out of a voir dire examination totally, confused about what it is that you're supposed to do at the end of this case. I mean, it's a common issue because the cases are so complicated. The laws are very strict, and you may not hear about them here in the beginning. You're not going to get the instructions until the end of the case. And so unless the lawyers can tell you here at the beginning of the case, all of that, and there's only so much they can do in the amount of time that they can. So don't feel like the Lone Ranger. You are.
No. I don't, but Judge Hunter, see, I've seen this at times that have taken place, because I think about what is a trial among the jury of our peers. And I've gone to some of these cases and I've thought, boy, if I were there, these are not my peers. I'm sorry, because I told you about my background and how hard I worked to get to a place where I had a bachelor's degree, a couple of graduate degrees, a position that I'm in, and then I'm going to be judged by somebody who's gaming all day. And I'm like, wait a minute, this is not a jury of my peers. A jury of my peers would be somebody that would be at least a little bit on the same level. So I always find that to be difficult. And as what you just said, though, is that if people don't know what they're looking at, it creates a lot of confusion, and people can make a ruling on something that they're completely confused about. And I think it's, especially in a case of parental termination, it's been called the death sentence in a sense.
Yes.
So this is very, very important that in this type of a situation that we know what we're talking about, what we're looking for, because we're basically executing a death sentence on a family, on a parent, on a child, whatever. So I think it's very important that that the jurors be informed and that the jurors know what we're looking at. So that's my defense of myself and my questions, because I would have actually had more questions as well, but I know that was not the place for it.
Well, and if I may too, just understand too, the adversarial role that we're playing, I need to make it clear. I'm trying to win.
Right, absolutely, you are.
And understand this.
And she's trying to win.
And look, Sandre and I have been against each other several times, and I know that she's going to do what she can to win, and I'm going to do what I can to win. And the voir dire process, I'm usually approaching it from the standpoint of, and the people who practice in this area know this. Yes, I want to get to know these jurors so that I don't be surprised by somebody being on there, but I'm also taking this as an opportunity to try to bring my charisma, make y'all like me, make you like me. And if you like me, you'll probably like my client better. I want to.
And we'll listen to you more.
That's right. And I want y'all. I'm trying to gauge the body language and trying to gauge your responses and seeing, do you like me? Because if you like me, I want you on my panel.
Yeah.
And I want you to like me more than my opponent. So hey, I'm wittier. Hey, I'm more deferential to you. I talk about, oh, I like your answer. Oh, that I like that. That really makes a lot of sense to me. Sounds like you and I are peers in that way. You and I are together. So remember that when you go to the jury deliberation room, remember who your friend is. I'm trying during the court dire process to make all of y'all my friends.
So forget about the evidence and the arguments.
Because I'm trying to win.
Well, and let me just interject here that this is probably the single point in the trial where these parties will be on an even level.
That's right.
Because from now on, Mr. Dunlop is playing defense. I mean, that's just the bottom line in these cases. I mean, from this point on, he's playing defense. It might look like, he's, chugging and rugging along right now, but things are about to get nasty. So, so he's going to end up playing defense, and that's why he has to come out swinging. He's got to come out swinging. So,
and just as an aside, thank you, just as an aside, I would have used my preemptive strike. Sandre and I would have been using our same preemptive strike, preemptive strike against you too, because I didn't want someone to be back there educating my jury. I want to be the one educating my jury. And you were so sophisticated and so knowledgeable, and your questions revealed that you aren't going to be a sheep. You're not going to be a person that's just bad. Hey, Mr. Dunlop said don't terminate, so we got to do what my friend said.
Yeah,
you're not that kind of person.
No, and I actually thought that you might terminate me too, or you might strike me as well. But it comes down to my initial point: the jury pool may be an uneducated jury pool that can be swayed, and I think that is very terrible in instances of parental right terminations, as it would be in the case of a death sentence. We know that the Innocence Project is around, that they defend people that have been incorrectly incarcerated or put on death row. And we need to make sure, if we want to have trust in our judicial system, that the jury pool is an educated jury pool, that they're not going to be swayed by persuasive arguments or by likability. It's not a likability test. It is an evidence test. So yes, I figured you would both strike me. And this is my problem. But honestly, this is my problem. You want to have a jury that you can manipulate, rather than a jury who might be educated and sophisticated, to use your word, and to say, wait a minute, this argument is not true.
Well, Mr. Morgan, I don't think you have anything to worry about, because the type of people who come to jury service are from all walks of life. The doctors, lawyers, teachers, professors, politicians, there you go, educators, police officers.
Yeah.
So long as they aren't too sophisticated, right?
Workers, they all show up for jury service, thank goodness. So, but it's so important. What you said leads us to the point that it's so important that people actually do come and serve on these juries.
That's the whole point of why I've done this for the civil courts. I've done this for the criminal courts, and now for the family courts, because people think of jury duty as something arduous to do, versus coming and giving of their civic duty in another place that as society we are responsible for. And listening to Sandre talk about, the termination, and also Judge Hunter talking about the termination of someone's parental rights, that pained me because you're talking about changing somebody's lives forever. And even when the kid turns 18, then they can go out and seek that parent and try to have a relationship with them. It has been damaged immensely. Not to say everything that led up to this proceeding has damaged everybody, but that is very extreme. And for me, the criminal side, where it has to be, the bar is really high because you're changing somebody's life with incarcerating them. To me, that's kind of like where the bar should be set with terminating parental rights. And
these cases are not meant to be easy. It's not meant to be easy. And people think coming into jury service, oh, this is not going to be a problem. No, it's meant to be thought-provoking to you. And Mr. Morgan, while you may not be the juror for this case, they would probably love you on toxic torts or in complex litigation where they need people to understand all the scientific evidence, that type of thing.
So, but what you're saying, Judge Hunter, and this is where I'm going to say with what Cydney said there, that, and I actually forgot, I was listening to you speak there for a moment, but I think that this is very important because when I said that to terminate a parent's rights or a parent-child relationship is a death sentence.
It is.
And we should not expect anything less. I've gone to courts and I've watched the juries that have been there, and they have made, in my opinion, some atrocious decisions. And I've watched people that I've thought, this person, I don't even know if they have anything more than a high school education and they're just watching MTV all day or something like that. And they're taking a person's life into their hands, or multiple people's lives into their hands. And what I've seen in family courts is that too often our constitutional rights are not protected. It becomes a place to persuade people. And somehow we've said toxic torts are up here, but family law is down here. Why do we say that?
That's not what I meant.
Okay, but I'm just saying that we should have the same type of standard. We should not be saying, I'm trying to win my case. We should be looking for justice and to do the right thing. Not to try to say, hey.
Case is justice, is what they're thinking. And
No, I know, and I disagree with their definition. But anyway, thank you.
Yes, thank you so much.
But let me interject just a motion if I can on the idea of because as just an average Joe public here as an educator, I would say I think we wade into some dangerous water if we start equating high school graduation with their ability to assess a case and what the merits of that case are. I think, and to be open honest, I actually represented myself in a case in the 330th. I fought for custody of my son, who's now 29 years old. So this is going back almost 20 years, and I had a very positive experience. I mean, everyone said, don't be your own lawyer because you'll have an idiot for a client and all those things. So I actually had a very positive experience, and I enjoyed the fact that you were able to lay out your evidence and talk about what was positive to your case, and then they presented their evidence. And this wasn't a jury trial; it was a bench trial. But for me, it was an interesting moment because I finally realized here I am, Joe Public, just an average guy, and I didn't even have a degree at that time, able to navigate a complex system that involves a parent-child relationship. And while this wasn't a death sentence because it was just a custody issue, I was very happy and very pleased with that process. And I think that oftentimes we have things that we can bag on about the system that we have because there are faults to it for sure. But I think coming from South Africa, where it was a complete crapshoot if you ever got into the legal system, this is a very solid system. I do like the fact that you can get a person on that might not even have a high school diploma, but would still be able to listen to the evidence, judge it, and evaluate it based on the standards that were given by, like Judge Hunter would say, this is the standard and the evidence that we have, and then judge it from there. I don't think you need to know, the Krebs cycle in a cell for biology 101 to be able to evaluate the parent-child relationship.
And that was not what I was saying.
I do want to close this out because it is 11 o'clock, so I want to be mindful of everybody's time. Thank you guys so much for coming on and walking us through. Judge Hunter, thank you for presiding over the mock voir dire. And Sandre and Stacy, thank you for walking us through those questions. And Euan and Jeff, thank you for participating. And I will say this, and Stacy and Sandre and Judge Hunter, just in closing, some of the rules have changed in family law cases that are kind of moving a little bit more towards that criminal, standard with evidence and discovery and whatnot. So it's kind of like the family courts kind of sit in between civil and criminal, where they need that balance of both of them to make those decisions. And it kind of sounds like it's moving in that direction. Maybe.
Thank you so much. Thank you so much for having us. Thank you, jurors. We really appreciate it.
Thank you.
Hey, thanks so much. Thanks, Cydney.
And real.
So when you get your summons, make sure that you actually show up and do your civic duty. And so next week, we're actually going to be talking about convalescent homes for kids and some of the issues that plague our youth when they're in those situations where the providers aren't always looking out for the best interests of children in that regard. So everyone, thank you so much. I definitely have to jump off and go to the convention this weekend. And everybody, looks like a lovely Saturday. Go enjoy your family and friends. Life is too short. Enjoy yourself. Enjoy everyone. Thank you, and see you next Saturday.
Thank you so much. Thanks, everybody.
Bye.
Bye now.
All righty.